Hello, everyone. Thank you for joining. I'm Matt Valier. I'm the Executive Director of the Institute for Patients' Rights, an organizational plaintiff in the lawsuit we're here to discuss today. I'll be your host. For the benefit of some people with disabilities, I'm an early 40s man of color, dark wavy hair, short cropped dark beard, olive complexion, wearing a purple and blue checked button-down shirt and a navy blue quarter zip. I'm in front of a blurry beige background. Our broken medical system is driven by a profits before people structure. People are not getting the care they deserve, and choices are often artificially limited by financially motivated players. Too often, medical professionals and society on the whole view life with a disability as less worth living, less worthy of care, scarce medical resources and healthcare dollars, better off dead. We have two experts here for you today who will provide our position, purpose, and arguments in the case we've filed in the United States District Court of Delaware to permanently enjoin the state's assisted suicide law, the so-called End-of-Life Options Act. We argue that the statute violates federal anti-discrimination law that protects the rights of people with disabilities and the U.S. Constitution. So with us today are Ted Kittela, who's the managing partner of Halloran, Farkas and Kittela in Wilmington, Delaware. Mr. Kittela has practiced law for 25 years and is a member of the bar of the state of Delaware, the bar of the state of New York, District of Columbia, and the United States Supreme Court. Mr. Kittle has appeared in every court in the state of Delaware and manages a law firm with attorneys in 5 jurisdictions. Denise McMullen Powell is also with us today. She's a prominent disability rights activist based in Delaware, known for her decades-long advocacy for accessibility, inclusion, and opposition to assisted suicide legislation. She's a polio survivor who has used a wheelchair for much of her life. Ms. McMullen Powell has worked with organizations such as ADAPT, Not Dead Yet, to fight policies that she believes endanger people with disabilities. Her activism spans grassroots organizing, legislative testimony, and emphasizing that assisted suicide laws often undermine safeguards and disproportionately threaten vulnerable populations. Through public speaking, op-eds, and oral histories, she has highlighted systemic barriers faced by disabled individuals and championed reforms that prioritize dignity, autonomy, and equal access to care. So today we had tried to schedule an ASL interpreter, and if that person comes on during the session, we will add them in. But for the moment, we have a live captioner. For those of you who may need that, please move your cursor around. You can see a little button at the bottom that says Show Captions. This is the CC symbol. If you just click it, you can turn it on. And then if you click the up arrow that is in that box, you can set the settings for that as well. We're going to take questions via the Q&A function. Also, if you move your cursor around, you'll see the little Q&A button at the bottom. If you click it, you'll see the screen come up, and you can ask your questions by writing them down. If you are from the press, please put your question, your name, and the media outlet. And if your question is for a specific panelist, please indicate that. And then for any further media requests, please contact Meg Tully at mtully@apcoworldwide.com. The session will be recorded, and we'll share a link on our platforms afterwards. For panel and hosts, anyone who's not speaking, please do keep your mic on mute. And Ted, I'd like to start with your explaining the Delaware case, what happened on Monday, and where things could go from here.
Well, thanks, Matt. And thanks so much for having me as part of this webinar today. It's a true honor to be representing the people on this case. And it's a true honor to be working with people like Denise that I've learned a lot about Denise over the past few weeks, and she is a fighter. So we've got some people that are real fighters on this case. And that's what this case is about. This case is seeking to challenge and to end Delaware's End-of-Life Options Act. This was an act that was passed last year, signed into law by the governor of the state of Delaware. It passed by one vote in our General Assembly. And it's a sad story, actually, on how this came about. For years and years, they were trying to pass this a law similar to this, and they finally did get it passed. And when they got it passed, the prior governor, vetoed it. And the new governor was elected, and he made it a priority. And during the last General Assembly, he ended up having it presented and put on his desk, and he signed it in May. The law goes into effect on January 1st, 2026, or sooner if the state of Delaware, if there are regulations that are approved by this. We have filed a lawsuit in the federal court in Delaware, which is the U.S. District Court for the District of Delaware. And we have filed what is called a motion for temporary restraining order together with that. Now, the lawsuit seeks to challenge Delaware's End of Life Options Act. I mean, it's called the Act at times. It seeks to challenge the Act by arguing that this is discriminatory and violates the Americans with Disabilities Act, the Rehabilitation Act of 1973, the Affordable Care Act, and it violates the 14th Amendment, Due Process Clause, and Equal Protection Clause of the U.S. Constitution, and the Due Process Clause of the Delaware State Constitution. We've made arguments that what this law does is essentially takes anyone with a life-threatening disability and labels them as suicide ready under the Act. The effect on people with life-threatening disabilities is profound. It's extraordinarily dangerous. The law on its face is discriminatory, and we're arguing to the federal court in Delaware that it needs to stop the enforcement, stop the implementation, and stop the enforcement of this act. As I mentioned, we have filed a motion for a temporary restraining order. What that is, it's essentially an order that goes into place seeking to stop the act from moving forward, from going into effect, while we're trying to figure out whether or not this law would pass constitutional challenges as well as the statutory challenges that we've alleged. So, in essence, if we are able to prevail on the temporary restraining order and the court enters that in place, we will have time to then appropriately brief what is called a preliminary injunction motion, where we seek to bar the enforcement of this act and essentially take it off the books. Right now, we have filed the lawsuit, and we have had our judge assigned to the matter, the Honorable Greg Williams, U.S. District Judge. He is now overseeing the matter. And we have a motion for temporary restraining order that we have asked the state of Delaware's officials that are the defendants in this case to respond to. So we will hear in short order. We've been in contact throughout the day today, trying to figure out what the briefing schedule is, but we could very easily have a fight before Christmas on this lawsuit. And so we are ready to go forward. And right now it's a very interesting position to be in, because Delaware, there are similar suits establishing sort of similar challenges to other state laws, but Delaware is the one state where this hasn't gone into effect yet. And just personally, from where I'm standing, the reason why we move forward with this, we did not want to see one person making a choice that was ill-advised based upon this law going into effect. And we needed to move as quickly as possible. So we're hoping to be heard by the court in short order, but right now that's where things stand, Matt.
Excellent. Thank you for laying that out for us. I should have said this earlier, but if you have just a second to self-describe, it's just helpful for some of our friends with disabilities. So I should have thrown that out there a little earlier.
Absolutely. I'm a white man, bald. I'm wearing a red tie. I have a suit on, glasses, and it's a blurry background behind me.
Okay, thank you. And Denise, you are with us from Delaware Adapt. Maybe you could just tell us a little bit about Delaware Adapt and what motivated both you and the organization to be involved in the legislative battle during that time, and what motivates all of you to be a part of this litigation.
Well, most of the Delaware Adapt chapter are people with disabilities, many with severe disabilities, and our allies. Um, I joined Adapt in 1996, and that's when Not Dead Yet group also began with Diane Coleman. And so along the way of discrimination against different people that I knew and against myself, as to how valuable our lives were or not, it became quite apparent that the fight was on. I never knew that before. I never realized how much society had a bit of disdain for the value of our lives. And I realized that over the years more and more. I had a life insurance company cancel my plan because of my disability. That was early on, before 96, but it happened. That made me a little scared. Does that mean I'm going to die and they don't want to pay off too soon? I don't know. But society has,
So Denise, I know I said it a little earlier, but maybe you could just both self-describe and like let people know what your personal disabilities are, just to help them understand why you might experience discrimination.
yes. I acquired polio in 1949. I was 3 years old. And there was an iron lung right next, very close to my bed. I spent some time in Walter Reed Hospital. Um, and they expected me to pass or at least be in an iron lung, those great big machines with positive and negative air being put in them. I escaped the iron lung and so took to crutches and braces for a few years, and now I permanently use a wheelchair. Oh, and by the way, I'm a white female wearing large glasses, and I have a mixture of red and gray hair, and I'm wearing a black sweater over a black and white sweater. So, what happened back then? Well, they expected me to die then, and I kept going past my expiration date for some reason or another. But if I hadn't have received proper care, and it's getting less and less available to me now, I could have passed. I could have if my parents weren't in the army, and so we got all kinds of things going on there in healthcare only because my family was military. I don't know
Could you
what would have
describe
happened.
what you mean by saying that it's becoming less and less available to you?
Well, the cost, and also I have Medicare right now, and Medicare doesn't cover the cost of nursing facilities, and it doesn't cover the cost of home and community-based services either, because it doesn't cover the cost of nursing facilities. So I'm at home, and so I have a very hard time getting the help I need to keep live and kicking. I have also, I'm pre-diabetic. My husband is full diabetic. And if we have no resources to support that, to support our lives having diabetes, we could very well become terminal. There have been people determined terminal in other states. And I assume that since Delaware's law is based on other states' laws, very, very similar, that can happen here too. And it scares me a little bit because I don't feel like I'm dying most times. Every once in a while, it gets a little bad, and I have a few dark moments. And what scares me the most is the availability of having access to drugs that can end my life. It's about the same as having a gun in a drawer to me, because you come across that dark moment. Like every once in a while, there's a little too much pain. And you're going to die anyway, someday, maybe 6 months, maybe not. Maybe not. But you feel that bad that you might have gone for that gun in the drawer. Well, when there are lethal doses of medication sitting on the night table waiting for you, that is just as dangerous and just as available in a dark moment. And that scares the living bejesus out of me.
Well, tell me a little bit about Delaware Adapt and how you got involved, and then why Delaware Adapt is so motivated on this particular issue.
Yeah. Well, I took a little trip all on my own one time to Atlanta, Georgia, when they were having what they call an action down there, fighting for the right to live in the community. And that's when I began to meet so many disabled people. And people back here joined us, and they became, I don't know, I wanted to say inebriated with the idea of having a little power over their own lives. But they became excited, and knowing that there is something more. There is a whole lot more to living besides on your way to death if you have a disability. And they got excited about that, and they joined me. And so we joined the fight for this too. I'm sorry, there's a background noise.
We can't hear it.
Okay. My husband is using a walker. He had a recent massive stroke, and it's a little rattly. So he's even more in the category than I am right now, and trying to stay alive and trying to remain a value to the community, which he has been all his life, and he still is to me, and I still am to him. But Delaware Adapt, we are very concerned because people with disabilities generally, and it does happen, die sooner than the typical people do without disabilities. But we don't need to hasten any of that along. And it's assumed with all these other people that I know in Delaware Adapt and myself that people are way too merciful in their understanding of why we might want to off ourselves, please. Okay. So, we're still alive and kicking, aren't we? Around this house. They're a little afraid too about those drugs being available and about the encouragement that we might hear from people that feel sorry for us and people that are kind of annoyed to have us around and getting in the way all the time, doing little actions here and there, and why don't you move along? I mean, you're not long for this world. And there's always relatives and all that they understand how much we suffer. And I've heard this through conversations with other ADAPT people too, and that they wonder why we wouldn't welcome such a thing to be available. They wonder, and they are shocked and surprised that no, we don't welcome the availability. Most of my friends, most of the ADAPT members are like, what? What do you mean we should welcome this? And relieve our suffering. And this is not palliative, which it was described in one issue of the bill, that it's palliative treatment, which was shocking to me. And they read that too and said, palliative treatment helps you not suffer. It doesn't kill you.
Right.
It helps you not feel the pain.
So, I mean, what we get a lot, and Denise, I'm sure you have too, is what does this have to do with disability? It's supposed to be for terminally ill people, and why are you raising such a fuss in the disability community when you don't even qualify? And so, Ted, maybe you could just give us a little bit of a legal framework of how somebody under the law as it's written, how somebody with disabilities would qualify and does qualify under the law.
Sure. And the way the act is written is the trigger for being able to be entitled to have life-ending drugs prescribed to you is that you have a terminal illness. And the terminal illness definition in the act describes people that are disabled. That's what it does. It says that the person has an expectation for whatever reason that they would not survive beyond 6 months. Now that describes a person that has a disability, as a person with a disability. And what we have seen, and I think with talking with people, that's just masking what the intention really is, what the intention of this bill really is. It's essentially telling people who are disabled, we understand that you cannot go another day. And so we're going to give you the right under this law to end your life within a period of 2 weeks. And that's literally what it takes is 2 weeks.
So is that, are you saying the law allows anyone with a disability to get lethal drugs with a doctor's help?
Not anyone, but it would be a person that would have a life-threatening disability. So let's just say that suddenly Denise does not feel that she wants to continue on. Denise is in a vulnerable position because she can make choices about what she's doing right now in her daily routine that would qualify her immediately as a person that has a terminal illness. One of the main persons that we have in this lawsuit is a gentleman by the name of Sean Curran. Sean and I have known each other since college, very close friends. Sean suffered a spinal cord injury at the age of, I think, 15. It was about 36 years ago. And he's a quad. He uses a chair every day. He needs help for eating, drinking, just basic toileting, all the sort of things that you would do in a daily routine. And the moment that Sean becomes slightly ill, and he had a bowel obstruction that he mentioned in the pleadings, he was placed in a position that he would have readily qualified under this act. And one of the things that he mentioned to me when I was talking with him was that he said there was a very dark moment for him when he was laying in the hospital after having to go back in three separate times for this bowel obstruction. And he looked at it and he said, I've lost the desire to live. And I will say that there's a lot of people that may be sitting in that situation. A person with a life-threatening disability is sitting in that position. And what this has done, what this law has done, is it has normalized a doctor or a nurse practitioner to essentially counsel that patient, well, there's another option for you. And that's the thing that's probably the most pernicious threat on this, is that suddenly it becomes the option that is offered to persons with disabilities.
Well,
That they,
yes, the thing that everyone, it's the only thing everyone has equal access to, right? Like, and that's some of what is really surprising to me about these public policies is you have people like Sean, um, or Denise or any myriad of our friends with disabilities who auto qualify for these lethal drugs at all times. And that could either be due to the many barriers to access that people face, our broken healthcare system, a specialist not willing to receive a referral because somebody is underinsured or uninsured. It could be literally any of the barriers to access, including racism and ableism. It could also be that the person is, as Denise described, in a dark moment, demoralized by a system stacked against them, facing constantly having to fight the insurer, the transport company, everyone in their myriad of care and their kind of network and matrix of care that they need on a day-to-day basis in order to survive. If they don't have these services and supports, people die, right? So that renders them having the 6 month or less prognosis, but they can also opt for that. That one can, in that demoralized and state, in a state of depression, which is sometimes hard to detect, request lethal drugs and get them. That's one of the great reasons why a group like United Spinal is one of the plaintiffs in this lawsuit, and the others. There are two other lawsuits pending against other states because so many people who are chair users and have spinal cord injury or disease, they face suicidality. There's high rates of suicidality among that group of people with disabilities, and when that is such a present reality for so many, um, you can see why the disability community is so concerned. Um, so
and
Ted,
Matt, I would add on something on that. That was part of the conversation I think that we had when we and these conversations have been made public as part of the lawsuit. Sean himself has said that when he saw this, when he looked at very closely at the act in Delaware, he said, "This is discrimination, plain and simple. Just because I have a life-threatening disability, I should not be labeled as terminal. So this law treats me as a second-class citizen simply because I have a disability." And I think this was, one of the strongest words that he said when he was looking at it. He said, "This is a true punch in the gut for people with disabilities."
yeah.
Talk
So
about punching down.
could you explain a little bit what the difference is, right? So like if somebody like Sean or anyone else with a life-threatening disability, so that could be like, look, like Sean's got any variety of complex medical situations, right? So he could
Sure.
either have barriers to access or opt to forego care. But it could also be somebody, I mean, there are people in other legal states that have qualified because they've didn't have access to or forewent their dialysis or their insulin, right? Like these are ways that people have qualified. Young women with anorexia who happen to get told by a medical professional that their case is hopeless. Now they qualify too, and they're getting lethal drugs under these laws. So what is it? How are people to understand who gets the drugs, who doesn't? And where's the line? Is there a line?
There is no line. It really depends on who the person talks to. And this law in Delaware will allow you to basically shop providers until you find the provider that will tell you, yes, you qualify and I can write something up for you. That's the unbelievable part on this is that not only is it a doctor, it's not just a doctor that can prescribe this. It's also a practicing nurse. And so we we have a situation where people that can meet by Zoom, a doctor who doesn't even know the person, doesn't know what they're going through, and suddenly that person can find themselves with a prescription for a life-ending drug. And that's the thing that's the most shocking thing about it. I mean, there's so many issues with this bill, the way it's written and the what it could do. First of all, I mean, if you look at how the reporting has to be done, the deaths under this law are not recorded as suicides. They're recorded as the terminal illness that, or the related terminal illness that led to the person getting the prescription. I mean, this is designed to hide what has gone on. There's
So
a
what
great deal of concern.
so what happens in every other instance of somebody requesting help and killing themselves in a medical setting? So like, say you don't have a life-threatening disability.
That's just it. Yes, under Delaware's sort of system here, what we have is we have suicide prevention counseling. So you can get prevention counseling. That's really the standard of care. Somebody comes to you and says, "I don't want to go on." Counseling is there for that person. If you have a life-threatening disability, that's not the option. The option is, well, there's a way that you can end your life.
So what happens to somebody in Delaware, a medical professional who helps a less or non-disabled person to kill themselves? What happens to that medical professional?
Well, that person actually under Delaware law would be that's a misdemeanor under Delaware law. That would be a crime. It's a crime to assist somebody in Delaware with committing suicide. And for anyone else, for assisting somebody with a life-threatening disability, it's not a crime.
Yeah, so like that's what is that's what a lot of people fail to realize, I think, in the kind of like larger debate on this. People always look at it as this addition unto autonomy, where people get more choices, and this is all putting power in the hands of the patients. The actual statute does nothing for patients. There's nothing in it that changes anything in the game for the patients. It does everything for the medical professionals. So it's basically sweeping criminal, civil, and professional liability off the table for somebody supposedly, quote unquote, acting in good faith. I mean, this is a much lower standard than anything else a physician or a nurse practitioner might do in their professional capacity.
There's no monitoring, and there's no monitoring, Matt. That's just it. I mean, the whole act was designed to essentially shield those doctors and those advanced practice nurses from any form of liability associated with something like this happening. I mean, what happens if somebody gets this prescription? They don't have to take it. They can actually leave it on their counter and somebody else takes it. I mean, there's just so many problems with this. There's no control over how many times that somebody has gone around and been denied and suddenly find somebody that's willing to sign off. I mean, we've just opened Pandora's box on this. But the purpose of our lawsuit, we're going to be highlighting all these things in the lawsuit to show how problematic this is. But this lawsuit is really about why this law discriminates against persons with disabilities, and that's what we're hanging our hat on for purposes of at least advancing the case here in Delaware.
Mhm. Thank you for explaining all that for us, Ted. Denise, what what are you seeing with regard in the community with regard to Medicaid cuts and some of what you had described earlier about it's getting harder to get care. What's the disability community getting? What are you getting from the community with regard to the cuts, and how do you think it impacts the situation with this pending, the assisted suicide law about to go into effect on January 1st? If, all things being equal, like obviously if our temporary restraining order is accepted, it would stay implementation, but what are people saying? What are they thinking? What are they feeling?
The more cuts there are, the less service that we'll get and the less treatments that we'll get to keep us around. We can live for a very long time if we have proper treatment and we have good medication, and the medication and all those things are available to us regardless of cost. And when Medicaid pays for, which it does for a lot of people with disabilities, a multitude of people with disabilities that have never been able to work and are in a low income, and that's their lifeblood. And when that's cut off or cut down, they can, some individuals, even more than some, can become terminal without proper care, not of their own choosing, not because they want to become terminal just through depression or something, but because it's not available to them. But this will be offered to them as an alternative when they can't get those proper care, when they can't get proper medications, when they can't have people come to their home to help them get in and out of bed. And they could get a bed sores from not having that service. And that could become terminal through, I don't know, infections. You can get UTIs, another type of infection, all kinds of things. Uh, if people aren't coming and helping you, if you're not getting those medications, if I don't have my blood pressure medication, if I don't have my cholesterol medication, I could become terminal. A friend of mine had said in his obituary that he died from complications from post polio syndrome. It said that in the obituary. And that's me.
Yeah.
That's me.
Well, let's turn to a few of the questions in the Q&A. I have a couple from Dr. Mark Comrade, who was our guest at our previous webinar. He's a psychiatrist at Johns Hopkins and an expert on this particular issue. He asks, as the Delaware law is available to the cohort of those with a 6-month terminal prognosis, is that with treatment or even without treatment? I think we covered some of that, but maybe not as directly as the question's asking. So, what do you have to say about that?
So I think that the law is vague on that. It basically just says 6 months. And I know that there's regulations that they are working on drafting right now. And my understanding right at this point is that there is at least some debate on this point. Um, my fear and Dr. Comrade is he is the true expert in this area. I think that from my understanding is that whatever it is, it's going to be the most permissive that you can allow a person to essentially refuse treatment and move yourself into that category. And so that's my concern.
And that's certainly been the experience in other legal states post legalization, is that some people who had either had perfectly treatable illnesses, and they opted to forego care, and who knows all of their motivations, right? That could be mental illness, it could be depression. It could also, like one young woman opted to forego care for a perfectly treatable cancer. And that the pro-assisted suicide doctors in the paper that I read was they were even saying like, look, I'm not going to help you because that's just suicide. You could get treatment and live for decades. And she just didn't want to lose her hair. She didn't want to go through the treatment. That was her real reason. And so she opted to forego care. But people who also get denied care, it's been asked by two health departments in legal states, if somebody gets denied coverage for care, will that make them terminal under the act? And the answer is yes. There are journal articles about a woman in Oregon who opted to forego food and fluids because of a dementia diagnosis. She had indicators. She was not yet experiencing the dementia. Cody Sontag, she stopped eating and drinking, and on day 5, she received lethal drugs from a doctor, and she died on day 8 from an overdose via those lethal drugs, not by stopping eating and drinking. And this was a perfectly physically healthy person. So yes, I think that with or without care has absolutely been the actual experience in other legal jurisdictions. Um, uh, Dr. Conrad also asks, so is the idea that a disabled person might be more tempted to stop the treatment that they need to survive past 6 months due to this new option? People with disabilities are not being called terminal, though. They have to make some choices that produce a terminal situation, right? Is that true or false? Denise, what do you think about that?
Thanks, Denise.
It's a it's a mixture. If they're in a dark place, it could be true, but it's usually false. It's usually the denial of treatment or the denial of having proper resources, and you can become terminal because you're no longer getting what you need to keep staying alive to your natural end.
Yeah, when you need it, right? So one of
And I,
the, go ahead,
I,
sorry.
I also realize that the law says that uh, you cannot get the drugs solely on the basis of age or disability. I understand that, but that doesn't disqualify people of age or people with disabilities from obtaining the drugs if they can get, even if they have to doctor shop, uh, if they get a terminal prognosis.
Yeah, so I think that there's actually a really a strong like a big problem with the statute, right? It says out of one side of its mouth, you cannot get this solely on the basis of age or disability, yet every single condition that renders a person having a 6 month or less prognosis is a disability under ADA definitions.
Right.
And so, whether or not one considers oneself a person with disabilities is irrelevant to the fact that uh, you would not be treated in this way were you if you did not have XYZ disabilities. Now, those disabilities rendering a 6 month or less prognosis. And so, but for the disability, and because of it, yeah, there's both disparate impact and um, whether the people believe it or not is a different question. Whether they perceive themselves as people with disabilities is different than whether or not they are. And the doctors prescribing solely on the basis of disability, they're not saying, oh, because you're disabled, but it's because you have this condition. And that condition happens to be also a disability, and that condition renders you having a 6 month or less prognosis. I mean, there's that's a distinction without a difference, and I think that that's one of the main problems in the writing of the law.
Yes,
Um,
there's also another, I'm sorry,
please.
misconception. Um, when it says in the law that you need to be, if you have a disability or if you have an intellectual disability, you might have to go to a psychiatrist or psychologist, uh, which would probably be a positive thing. However, that psychologist or psychiatrist is not talking to the person with a disability, as all of them have, uh, that have been gotten that prognosis. Um, They're only there, according to the law, to determine if you have the ability to make decisions or not. They're not there to assist you or to talk to you or to see if that's what you really want to go that route or not. They're not there to help you at all, but only to determine whether you have the capacity to make decisions for yourself. That's it. And
Mhm.
about less than, on the average that I've read about, less than 3% of people are referred to that type of behavior counseling.
That evaluation, yeah, and in fact, there's at least one study that shows some 25% of people who got the drugs were clinically had indications of clinical depression. So, like,
Yes.
what are we talking about here? Um, I'm going to move to another question. Um, Laura Bogley asks, "Are you concerned that if so she's trying to understand the establishment of discrimination. She says, are you concerned that if you say the law only allows assisted suicide to be offered to those with terminal illness or disability, that the response would be that they would need to make assisted suicide equally accessible to all instead? Is that the solution?" I mean, I added the last question, by the way. So that's Laura Bogley's question. Is it is the other side solution assisted suicide for all? Question mark.
Let me put it into a sort of a legal framework. And the legal framework right now is what we have is we have a law on the books which is facially discriminatory. That law cannot stand. So we would have to challenge that law. Now, at that point in time, if we prevail on this, and for some reason it's not appealed, and which I think I would be very, very surprised that if we were to prevail, that the state would not appeal this to the Third Circuit Court of Appeals, which is the next court up, and would not appeal this to the United States Supreme Court. If for some reason this law failed, excuse me, this law would have to be struck because it's discriminatory. They would have to go back to the drawing board, and going back to the drawing board would mean removing the discriminatory provision on there. At that point, I think the debate becomes very, very different. Are we as a society ready to make suicide available to any person on demand? And that becomes really the question that people have to face. Now, we have another sort of issue with the law. Even if you were to go forward and say it's, remove the discriminatory provision on there, we believe that the law doesn't pass muster under what's called the due process clause. And that even at that point in time, even if the discriminatory provisions were removed from this thing, that under the due process clause, you cannot have a two-person death panel making a determination over human life. And that right there, I think, is a very potent argument. I think it's very strong. But yes, there is a risk, that we could be facing bigger challenges on this. But right now, my focus and what we have to be laser focused on is that the law as written and on the books right now, and that they got passed by one vote, has to be struck down because it cannot be on the books as it is.
Yeah, it seems to me too, like, we're this, we win the lawsuit, lock, stock, and barrel. You go all the way. And the law is overturned. Given that this law was passed by a singular vote, it seems to me very unlikely that neither the legislature nor society is ready to offer a physician's help to a young person with a messy breakup at like 18 years old who just has like a momentary suicidality, right? Like no one's gonna do that. No one's gonna pass such a law, at least not in our times and in our society. However, and it also flies in the face of like billions of dollars we spend every year in suicide prevention care and services, both as governments, like, federal, state, etc., and nonprofit organizations. I mean, like, this is this is a major effort. It's an epidemic, according to the House of Medicine. I mean, like this is seemingly untenable. But it does seem to me too that you, to for the government to deprive somebody of a fundamental right like their life, um, these laws are so loosey-goosey that it doesn't even come close to due process that one would experience in any other venue of this nature under the law. So,
And Matt, I would add to that. I don't see how you fix this law. I really don't. I mean, we could try to come up with a million and one scenarios where maybe this could happen, you know, and like I said, I'm laser focused on what it is that we're trying to knock down at this point in time. I understand that there is a bigger debate that goes on in other places about this, but I don't see how under Anglo-American jurisprudence that we would have the ability to have a law such as this on the books. It just doesn't, it flies in the face of our history. And that's probably one of the arguments that the US Supreme Court's ultimately going to hear.
mhm. So we have another question from a V Darling. Now, to be clear, I'm going to preface this question. The Institute for Patients' Rights and the Patients' Rights Action Fund, the two organizations I would represent, we're a secular nonpartisan group, and we have just a very small cadre of issues that we deal with. And abortion is not one of them. And it seems to me like this question might be trying to conflate the two issues, but I want to just preface that by saying like they are different issues, and there are different considerations. There are many people on both sides of that other issue, of the abortion issue, who are all opposed to assisted suicide. Then there are people who are on both sides of that issue who aren't in favor of assisted suicide. So our issue doesn't cut down those same lines. But the question is, do you think the Dobbs decision will help this case in the Supreme Court if it gets there?
Really good question. I'm not certain. I'm not certain. There are parts about Dobbs that I'm concerned about, where it basically says that the states become these little laboratories for doing all sorts of experiments. Um, this is something I don't want. If this law is considered to be one of those things where let's give it a try and let's do an experiment with this law, this is a terrible experiment. This would be a terrible sort of thing. That's the reason why I jumped into this case right now. It's the reason why I'm going full force to try to keep this law from going into effect. I think that one life lost under this law is too many. So I am concerned with respect to certain characteristics of Dobbs, where it would say that the states need to do that. That said, there's a lot of helpful language in Dobbs as well regarding just sort of our due process outlook and how we would approach this. So I'm a lawyer. I'm going to borrow from wherever I can find my support. And sometimes that means, citing cases that ultimately you may end up disagreeing with on other things. So forgive me for doing that, my job on that one.
Yeah. Well, we just have a couple minutes left here, but I would say too that on the assisted suicide front, the other side tried to take a case that would have established a right to assisted suicide in the Constitution in the late 90s. That case failed 9-0 at the Supreme Court, Glucksberg. So instead of getting a sweeping victory as they were hoping, they ended up with a Dobbs-like loss back then. This is why this has been legislated primarily in the states. You don't see a lot of action on this at the federal level. So we aren't taking these lawsuits in order to try to undo a precedent. set by a previous ruling. This is a case that's completely different in nature, that's claiming that these assisted suicide laws that have been passed at the state level fly in the face of, they violate federal anti-discrimination law and the Constitution, so they cannot stand. That's the basic legal evidence.
And Matt, let me be clear about something too. I greatly admire the Dobbs opinion. I really do. And that just from my own personal standpoint, I admire it a great deal. I think that in this case, where you have something that is facially discriminatory as drafted right here, I don't see how you can't have a situation where you have a Dobbs scenario where you're saying, you know what, we'll just let the individual states continue their discriminatory practices. That can't happen. That's the argument right there where we'd say that Dobbs doesn't work for this because on its face where it's discriminatory, you can't even pass muster. So
we have a question from Dr. Ann Hansen, who's also a psychiatrist that we happen to know at Johns Hopkins. She says, I'm concerned about the implications of assisted suicide laws for people in state institutions. Some prison systems have palliative care units. State psychiatric hospitals have patients with both serious mental illness and potentially life-shortening medical conditions. Suicide contagion is a well-documented phenomenon, and California health regulations require state psychiatric hospitals to provide lethal drugs. Would courts consider the risk to third parties in these institutions?
good question. Right now, the way the law is written, I think it's probably outside the scope of where Delaware is, but it's not even a full step to get to that point. It's a quarter step. I mean, it's so close right now from where we are. When you have a person that's in an institution, they're a ward of the state, and they're considered to be looked over by the state. And so I don't see it as being a stretch for us to get to the point where we would have a state system where it's outside of the control of the people that are the wards of the state.
Yeah. Well, thank you, Denise and Ted, for your thoughtful insights on this lawsuit. Denise, do you have any closing remarks before we end the press conference webinar?
Only that often when there's dark days, if you don't have a disability, you get to see a counselor. If you have a disability, you do not.
Mm.
You're looked at as worthy of doing what you need to do to get rid of yourself, whereas the non-disabled person gets help.
Yeah.
And we don't. But thank you for having us.
Yeah, thanks so much, Denise. Thank you, Ted. Thank you all for joining us today. Thank you to our ASL interpreter and for our live captioner. We very much appreciate your making this accessible to everyone. And to all of our participants who listened with us today, if you have any questions that you didn't get a chance to ask or that you haven't yet formulated and you kind of percolate on it, if you would like to ask those questions, please do send them to us. You can send them to me and I can get them to the panelists. My email address is matt, M-A-T-T, at praf.org, Paul, Ralph, Adam, Frank. And then for anyone who has media inquiries, please do contact Meg Tully, that's M-T-U-L-L-Y, at appcoworldwide.com. And we'll keep everyone posted. This lawsuit's unfolding fast, as Ted said. We could end up with a hearing on the restraining order next week. We could also have some real action on this in the first part of the year. So stay tuned. Thanks, everyone.